Bismillahirrahmanirrahim. Assalamu alaikum, all my dear students. Hope all of you are doing great at your places and taking all precautionary measures in this prevailing situation. So, we were discussing about the examination of witnesses, chapter 10 in Kanun-e-Shahadat Order 1984. In our last lectures, we discussed about the cross-examination, the examination in chief, leading questions, and other things related to these topics. So we are just continuing with that. Today I'm going to start with article 144. As in our previous lecture we discussed about the questions which should be asked and which should not be asked during cross examination. So we are continuing the same thing in today's lecture. So article 144, it basically states that question not to be asked without reasonable ground. No such question as is referred to in article 143 ought to be asked unless the person asking it has reasonable grounds for thinking that the imputation which it conveys is well founded. As discussed in previous lecture, when an advocate is asking any question which is basically intended to shake the credit of the witness, which is basically intended to injure the character of the witness, such type of questions, a greater degree of care is attached to them by the law of evidence. That is, an advocate shouldn't ask any type of question like this without reasonable ground to believe so. He must have reasonable grounds to believe for asking that question. I mean to say, you can't ask any person, are you a thief? And you don't have any background knowledge or information about that question, but you are asking it just for the sake of injuring the character, just to annoy, just to insult the witness. So this is basically bad and inappropriate and disliked in Kanun-e-Shahadat order. Next article, we are moving to procedure of court in case of question being asked without reasonable grounds. So now the scenario is that the question has been asked and it has been asked without reasonable ground to believe. Now what would be the way forward? The way forward is provided in article 145, which states that the court thinks that the question asked by the advocate, by the attorney, has been asked without any reasonable ground to believe so, and there were not justifiable reasons for asking that question. The advocate wasn't having any rigorous, any background information, concrete evidence for asking that question, and this question has been asked just for the sake of injuring the character of the witness, just to confuse him, just to confront him, or just to annoy or insult him. Then the court have multiple options. The court may refer that matter to the High Court to intervene in this regard. Alternatively, the court can also refer the matter to the concerned bar council. For example, if the advocate is enrolled with Pakistan Bar Council, with the Punjab Bar Council, or with the Sindh Bar Council, so whatever bar council it is, the court may refer the matter to the relevant bar council, and the bar council will investigate, will look into the matter and decide accordingly. And if the advocate is found guilty, he or she may be penalized as well. We have discussed some provisions are provided related to this in legal ethics in Legal Practitioners and Bar Councils Act 1973. So there are certain rules provided regarding the conduct of an advocate with regard to the other advocates, with regard to the clients, with regard to the court. In those rules and regulations, it is also provided that the advocate should behave rationally, logically, and reasonably. He shouldn't be offensive, imputative, and extraordinary aggressive in asking the question just to get the praise of his party, that look, my advocate, he spoke like this and that, he said so and so to the witness of that party, and the witness cannot respond that. So this type of behavior will not be appreciated in the court. You must have reasonable logic and grounds to believe so when you are asking a typical question which is related to the credit of the witness. So this an intensive degree of care is attached to this tool of cross examination, which has been extensively provided to the advocates to extract the truth from the witness provided by the opposite party. And this is the basically guideline. This is the basically benchmark to test, to check the application of this tool of cross examination by the advocate, whether it was justified or irrational. So in this regard, basically the court has an important role to play, that it need to look into the matter, that what is the line, where the line is being crossed, and whenever it is being crossed, the court has to intervene, the court has to stop that question, the court has to stop the process of cross examination. So the role of the court is very important in this regard. If the judge is not taking any pain, and he or she is not intervening at the right time, and he or she is not blocking this type of question, or he or she is not reporting such type of matter, I think this would be a huge prejudice for the witness. Then the witness will not be appreciated to come to the court and to give evidence in the court. So this is also necessary to safeguard, to protect the witness from the unfair usage of a tool of cross examination by the adverse party. Next, we will move to Article 146. It talk about the indecent and scandalous questions. The court may forbid any question or inquiries which it regards as indecent or scandalous. Although such questions or inquiries may have some bearing on the questions before the court, unless they relate to fact in issue or to matters necessary to be known in order to determine whether or not the facts in issue existed. Okay, look, if the question which has been asked during the cross examination, if it is indecent, if it is scandalous, okay, and it is related to the matter but remotely, I mean to say, the question will not seriously affect the course of business of the case in hand. It has like 20 to 30% relevance with the matter in hand, but it doesn't have any direct connection or any material relevance to the matter in hand. Then the court may forbid it. Okay, but if the question which is being asked is indecent or scandalous, but due to the fact that it is directly related to the fact in issue in hand, or if it is related to the one of the relevant facts involved in the case, then the court may allow this. So this is the basically a checklist the court will have to apprehend and apply it according to the circumstances of the case. For example, if the question being asked, the court think that this question is scandalous or it is indecent, then the court thinks that it is not too much related to the matter in issue, okay, then the court can forbid that question and block that question. But if the court thinks that, okay, this question is, although it is scandalous, although it is indecent, but due to the fact that it is directly related to the fact in issue, for example, if it is directly related to the question that whether person X is the murderer of person B, this is the fact and issue, and the question which is asked to the witness is directly related to this question, or if the question is related to any of the relevant facts, for example, any question which is related to the motive, cause, effect, opportunity, affording an opportunity, providing sustainable circumstances for the commission of that offense, if this scandalous question is related to any of these relevant facts, then that question may also be allowed by the court. So basically the discretion of the court applies here as well, and the court is required to apply this discretion judicially and reasonably. Next, I would go to Article 148, questions intended to insult or annoy. The court shall forbid any question which appears to it to be intended to insult or annoy, or which, though proper in itself, appears to the court needlessly offensive in form. If the court, look, the discretion of the court applies once again in this Article 148. If the court thinks that the question is basically intended to insult or annoy, the basic motive, the basic objective, the basic intention of the advocate of the party is to insult or to annoy, the advocate is coming with this objective to ask that question basically, then the court will apply its discretion. although the question is having a little bit relevance with the matter in hand, but as the court thinks that this question has been asked with the intention, with the motive to insult the witness, that's why the court may stop that question, block that question, and the court may ask the witness that, okay, you are not bound to answer this question. It's extremely up to you. If you want to answer this, you can, but if you don't, we will not mind it. So this is article 148. So basically in this lecture we discussed all in this lecture and in previous lectures as well, we discussed different types of questions which can be asked during cross-examination, and and the questions which cannot be asked during cross-examination. We started from the questions which are related to fact and issue can be asked. Then we talked about the questions which are related to the relevant facts can be asked. Then we talked about the questions which are intended to test the veracity of the witness, the questions which are intended to shake the credit of the witness, the questions which are intended to know who the witness is and what is his whereabouts. So basically these questions can be asked during cross-examination. Then we discussed which questions cannot be asked. So we discussed that the questions which are needlessly offensive, which are annoying, which are insultive, which are scandalous, these type of questions, and even without any justifiable reason to believe so, these types of questions are not allowed to be asked during cross-examination. So basically the court will decide in these circumstances whether the question is need to be allowed or it need to be blocked. Thank you very much.